Right, let's expand on this. We're joined now by our constitutional law expert advocate Michael Osborne. A very good evening to you. Thank you so much for your time. Just a day after he led the Umkhonto weSizwe Party's official manifesto launch, the ConCourt's now found that the former president is not eligible or even qualified to stand for election to the National Assembly. What do you make of this outcome?
Good evening to you. I think it's a fairly predictable outcome. The legislation, as Section 47(1)(e) of the Constitution and the allied legislation is fairly clear, and I think the president and the MK party had a difficult time in maintaining that, notwithstanding what seems to be the clear intent of the law, Mr. Zuma was not disqualified for a period of 5 years from standing for the National Assembly. I think it's a fairly obvious, fairly easy outcome.
And how did Judge Leona Theron reach this outcome in purposes of just expanding and broadening the understanding of Section 47(1)(e) of the Constitution?
Well, first of all, apart from the specific language, Justice Theron focused upon the purpose of the constitutional provision. And she made the point that under our closed list system of proportional representation, it's not the electorate that chooses who will go to Parliament, it's the parties that choose who will go to Parliament. And she put it in a rather interesting fashion. The purpose of Section 47(1)(e) is to prevent political parties from foisting upon the electorate people who are objectively unqualified to sit in the National Assembly. So that's the purpose, and the purpose is to preserve and vindicate the integrity of the electoral process and the outcome of the election. And as she put it rather eloquently, that's the inevitable interpretation of Section 47(1)(e). Mr. Zuma and the MK party had some rather sophisticated attempts to interpret 47(1)(e) to the contrary, but those weren't found to be persuasive. And it's interesting that this is a decision of unanimous court. Unlike in some of the previous decisions involving Mr. Zuma, they were dissenting or concurring opinions. There was absolutely unanimity. Furthermore, the other part of the court that is significant is that it decidedly rejected the proposal that the court needed to, or members of the court needed to recuse themselves to the extent that they had previously handed down the contempt sentence. And they held that the test is whether a reasonable person would reasonably put the members of the court to be incapable of deciding a fair judgment. The court said rather unambiguously, and in only a couple of paragraphs, that the mere fact that the court had previously made a decision finding Mr. Zuma guilty of contempt and then sentencing him to 3 years, that itself did not mean that the court was just enabled from an interpretation of the constitutional implication of Section 47.
Advocate Osborne, I'm hoping the line will hold for a little longer because you appear to be breaking, but let's keep talking. I mean, you talk about the sophisticated attempts that were made by Zuma's legal team. Of course, we know that argued that the type of sentence being a civil conviction meant that Section 47 did not apply. And the ConCourt went further to say that the IEC was empowered to make that decision to exclude Zuma ahead of elections. Of course, just now thrashing out the bone of contention, which was raised by Zuma's legal team. What were they trying to get to, and how has today's outcome now shown that there was no merit or substance to their argument?
Well, as for the outcome, it's a decisive outcome in the sense that there is no appeal. The Constitutional Court is the apex court. And there's really nothing further to be said on that. On the message, and apart from the importance of constitutional democracy and the integrity of the system, the court also made the point that it would be inconsistent with the dignity of the Constitutional Court to say that, unlike even a decision of a magistrate's court, its sentence could not be deemed to be a sentence by virtue of the fact that there was no appeal. And this was the argument, perhaps the foremost argument from Mr. Zuma's counsel, which is that insofar as there's no appeal from a constitutional court sentence, therefore it cannot be deemed to be a sentence at all for purposes of the Constitution. The court made the point that that doesn't follow at all. It's still a sentence. It just happens to be a sentence which, by virtue of the fact it's handed down by the Constitutional Court, is not appealable. There's nothing extraordinary about that conception, I think.
What we do understand is that Zuma cannot represent the MK party as an MP in Parliament due to his conviction. But what does this ruling by the ConCourt actually mean for Zuma's political ambitions?
Well, it simply means that he cannot sit in the benches of the MK party, assuming that they win enough seats to allow him to sit. It doesn't mean, of course, that Mr. Zuma cannot remain the power behind the throne. It doesn't mean, as I think your reporter mentioned in the beginning, it doesn't mean that he won't remain on the party, that his face won't remain on the ballot. So it really means that he simply won't be able to sit as an MP. But you might say, as a purely political matter, that doesn't make any difference, because he can continue to run the party insofar as he has unambiguously the dominant position politically within this party.
Very well. Thank you so much. Thanks for weighing in on this discussion.